Litigation is a process, and we're often asked about the segments of the process. And some of the key questions we usually get is, what is a deposition, what is a mediation, and what is trial? We'll start with deposition. Deposition is a proceeding where an individual gives sworn testimony. It typically takes place in an office or conference room setting and seems informal. But don't be tricked. Deposition testimony is sworn, it's under oath, and it's subject to being used at trial just as if you were sitting before the judge and jury. That's why it's vitally important to work with your attorneys in preparation for your deposition. Here at Patterson Law Group, we understand the importance of depositions. We understand that body language is important and how you say things is important. So we work with our clients to get them comfortable with the process to make sure when they walk in to give their deposition, they can tell the truth and do it in a convincing fashion. Another part of the process we're often asked about is mediation. What is it? Mediation is a proceeding that's confidential, and it's simply meant to see if the parties can reach a resolution. You have a third-party mediator. He or she does not represent either party. They represent settlement. They work with the parties. They talk to you about the strengths and weaknesses of your case. They talk to the other side about the strengths and weaknesses of their case. The idea is for the parties to come together, both to be reasonable and try and reach a resolution. It's a non-binding proceeding, and it's not required by law. However, most courts are requiring it for every case. So you can almost guarantee that you're going to have at least one day to devote to trying to resolve your case prior to having to move toward trial. So if you go through mediation and you don't resolve the case, and you don't resolve it informally between then and the end point, that end point is trial. Trial is where you go before a judge and a jury of your peers. You get up, you take the stand, you testify as to what happened. The other parties with knowledge of the events give their testimony. The lawyers argue. The proceeding usually takes anywhere from 2 to 3 days to a couple weeks. It's stressful, it's risky. Trial is a guaranteed right by the Constitution of the United States. It is the ultimate tool for litigants. It's the way to get your justice, but it's also the ultimate risk. There are no promises when you walk in the courtroom, and you should have very detailed conversations with your counsel before you make that decision and go in and try your case.